Okay, well, thank you, Sarah. And Sarah, two Sarahs this morning. We'll start this presentation. I just want to make sure I have this right. Okay. So, good morning, everybody. And my name is Doug Carstens. I'm an attorney with Carstens, Black and Minteer. And we had actually represented a group in the city of Monterey Park. That group was No Data Center, Monterey Park. This case study, first of all, I wanted to thank, especially again, Sarah Friedman. This is going to be more focus on one specific happening. I think the big picture was very, very comprehensive and covered a lot of what I would cover. So I think I'll be able to go very quickly here. Just really quickly, our law firm, we represent community groups and environmental groups, and our bread and butter is the California Environmental Quality Act, or CEQA, but we also do election law, and that was one of the reasons we were called specifically about this, because there was already contemplation about what may happen, one of the options being a ballot measure, which we'll get to. So just a quick background on the specific site. This site of the proposed data center was at 1977 Saturn Street. Even though this story is about one specific data center proposal, that's not the full picture. That's just kind of the center of the storm, or the overall events in the city, and an illustration of the various things like Sarah talked about that can be options. A lot of those options were explored as this was proceeding. The site was bought in about February 2025. In Roman numeral 2, about how developers will approach permitting. There's lots of options. There's the sort of quiet approach and just working with city staff, and there's some developers who will go out into the community and kind of knock on doors and meet in people's homes before proceeding with their application, or as their application is pending. So there's a few options there. And 3, the options pursued in Monterey Park. We'll have on a couple of the following slides how things played out and could play out differently. Implications for the future we'll get to as well. So just really quickly about what exactly this particular proposal was. It was a facility of, say, 250,000 square feet, the capacity being 40 to 50 megawatts. You can see the median over on the right in California is about 28 acres, and the average is 130. So this was actually a small size of a 15-acre site in a rather urban kind of area of the city. It's just about 5 miles south of here, right? Everybody kind of knows Monterey Park. And the distance to the community was about 65 feet, where a lot of other places will have a separation of, say, 1,500 feet or a lot more separation. So you can tell from the picture on the previous slide, it's kind of a business park, light industrial. It's an area where at a certain level, something like this was acquired because people thought it would make sense and it would go there. But on the other hand, for the impacts that would be concentrated in the kind of size of the site, that is part of what made this a particularly, let's say, challenging or difficult proposal. Let me talk on the next few slides about the California Environmental Quality Act generally. Can I show of hands, people either heard about it or very familiar with the CEQA as the acronym, California. Yes, this is, thank you, California's primary environmental law in a way that a lot of projects are reviewed. It's not the only way. Certainly, municipalities also control zoning and review processes for building permits, things like that. The California Environmental Quality Act, it only applies to discretionary projects, right? If it's ministerial, if there is a by right proposal, if zoning allows a certain use, then there wouldn't necessarily be a review under the California Environmental Quality Act. This is what this slide is illustrating. If there's an exemption from CEQA, that means CEQA doesn't even apply at all. And there's various kinds of exemptions that could apply. They can be categorical, they can be ministerial, they can be statutory. There's different ways essentially to stay out of the CEQA review process. If one claims the exemption, that's option 1. Option 2 is what's called a mitigated negative declaration, where there's no impacts. Option 3 is an environmental impact report, and this is what sort of has been called the heart of CEQA, or the most, let's say, involved document that will require a lot of review and public involvement. If one were to go on the first path, the claim of exemption, this is what I mentioned. If data centers are by right, if local zoning allows them specifically in a certain area, like an industrial zone location, then there may not be any discretionary decision to make. There may not be any environmental review to go along with that. If a local entity has a ordinance that allows it under certain conditions, like a conditional use permit, then there may be a discretionary decision that would forbid the claim of an exemption. State legislation may cover this. There is some controversy about, there was a bill called SB 131, which would exempt advanced manufacturing. There are some claims that data centers may be part of that. There's some claims that they're not. So that's still a open question about whether state. Actually, the slides that are up here I see are different from the ones I have in front of me. The title stayed the same. The claim of exemption, whether it's by right or state legislation covering, that's one course. Another course would be what was called option 2 for a mitigated or basically a straight out negative declaration. Some negative declarations don't even have mitigation measures. So those are called negative declarations, whereas the MNDs have mitigation measures, and then after the mitigation to address impacts is included, then the public agency can determine that to be not an impact or to have no impacts and do an MND. And then the last route, or option 3 under CEQA, is the environmental impact report, or again, the full document for doing environmental review, analyzing alternatives, understanding the impacts of a project. Like, again, back to Sarah Friedman's slides, those various water usage, energy usage, traffic, anything that might be an environmental impact report about these data centers would be in that environmental impact report document, which the city would then subject to public review and comment, usually 45-day comment period for the public to address their understanding of these impacts, and then respond to those comments. And under CEQA, if there are significant impacts that are associated with the project can still be approved under an overriding considerations, a statement of overriding considerations. So CEQA doesn't necessarily just stop the project. It requires mitigation and then understanding of impacts and moving forward with the project in light of those impacts. Next, I'll turn to what actually happened in Monterey Park. This is about the, I want to say the 8th slide. And that one actually already has all the notes in it, even on this version. So I'm pretty sure we'll see that. In October 2024, the prospective developer of the Monterey Park site submitted a proposed negative declaration, which was option 2, remember. And the South Coast Air Quality Management District submitted comments and said, well, there's actually going to be thank you, that's perfect. Again, still trying to go very quickly here. Air Quality Management District, or AQMD, said there would be impacts that weren't necessarily covered by that negative declaration. And that, along with other comments from the public, essentially, let's say, push this process toward an environmental impact report. So there were enhancements in October, et cetera. But then by December, the community essentially demands for an environmental impact report, the full understanding of impacts, triggered some discussion, and on the next slide we see actually a voluntary agreement to pursue an environmental impact report. This is in the top left. The bottom right, or the right hand, happens more during the process of review. So at the same time as deciding to do an environmental impact report, the city also decided there needed to be a moratorium on development. And a lot of jurisdictions will do these moratoria as a way to slow things down and understand what can be done or what options are available while environmental review is being done or other options are considered. One of the other options considered in February 2026 was to put a ballot measure on the city ballot to actually prohibit data centers altogether, not just have an ordinance that might regulate them and allow in certain phases, but to outright prohibit anywhere in the city. So this is, and the city attorney called this a belt and suspenders and girdle approach. I'm not the city attorney, I'm for the groups outside, but the city attorney was advising the city on how to respond to and what options to create. The belt, suspenders, girdle was referring to the moratorium, number one, as a way to kind of stop and slow down development for analysis. Number two was a city ordinance or legislation at the city level that the city council can pass, and the city council can either just ban or regulate data centers depending on that legislation. And number three, the girdle part of this would be the ballot measure, whereby the electorate could itself directly prohibit data centers throughout the city. And all three of those things could be done at once, or one or the other could be chosen. Because, again, belt, suspenders, and girdles, not all three are needed. In March, the developer withdrew the proposal. The council voted to initiate a ballot measure process by itself putting the ban on the ballot for the city council, for the city voters to have a voice on. In April, in between the March and June dates, the city council itself passed a legislative ban on data centers. Whether or not the initiative or ballot measure would have made it, this would have been effective in banning data centers within the city. And then in June 2026, there was a vote at the ballot box. This measure to ban data centers altogether was overwhelmingly adopted, 86%. It's just an outstanding vote in the city, and that was historic. It was the first in the country, which I commend the mayor of Monterey Park for leading the city through this process. The last slide, and then we'll like to either turn over to Q&A or to those remarks from the mayors. The reactions of communities, they vary so much. As again, Sarah had that great chart of the different types of communities, great categories, 4 of them, and some communities will be very supportive of data centers. That may be they're on the right, support and advocacy. If there's a need for the economic development, there's a perception of the want and desire for data center activity in the city, then that's one constituent. There may be some very heavy opposition, and that's sort of over on the left. There may be initiatives because community members feel like that's the only way they can participate or want to engage in their city. And in the middle, there's potential opposition. Some places, if the council and electorate are kind of at odds, sometimes the electorate will respond by referending an action by the council or opposing during those council meetings, and then possibly litigating. That is one outcome, but it was fortunately not necessary here. The council and the electorate were in full accord on how this happened. Again, wanting to go very quickly, we've already covered, or Sarah covered what's happening around the state and nationally. So with that,